Court's calling 2017-377, State of Arkansas versus Javis Curley. There's also 2017-370 involving the same defendant. Court is making the appointment of Public Defender's Office to represent Mr. Curley in case 2017-377. I believe you're already appointed in 2017-370.
We are, Your Honor.
In 2003-77, this is for arraignment on charges of possession of a firearm by a certain person and possession of drug paraphernalia related to methamphetamine or cocaine. Both of those are Class D felonies. How does the on these charges, how does the defendant now plead?
Your Honor, there's a plea of not guilty to all charges.
This case is assigned to the Division III docket of Judge Putman. Is there any kind of motion to transfer to combine the two cases?
Yes, Your Honor. I would move to transfer 377 to Division 4.
All right. So we'll enter an order to transfer 2017-377 to Division 4 and entered a plea of not guilty, appointed the Public Defender's Office. All right, well, I'm going to set him down. I'm sending both cases. Scheduling order. Where he'll be set for trial the week of March 26th, 2018. That's in both of these cases. I'm scheduling a pre-trial for February 22nd. And a reappearance on January 25th. On both of those cases on this court's docket. Are there any other matters to take up at this time?
Your Honor, I understand there's 5 separate cases now that we're representing Mr. Curley on. Is there a combined bond on all 5 cases?
Your Honor, we had this gentleman. I'll wait.
Yeah. Unless I know the case numbers of the other cases, I don't have any way to look them up.
I can tell you, Judge, the last time you set a bond for this gentleman was $12,500. That would have been in case 17-370. It was $12,500. There was some additional stipulations that he was not to drive, weekly drug test, and no drugs or alcohol. If he failed to that, he would go back to jail. Your Honor, the man is entitled to a bond. However, this gentleman has been arrested 5 times in the last 6 months, less than 6 months actually, less than 180 days. Most of those charges. He was arrested March 25th for possession of methamphetamine, no driver's license, no insurance. He was arrested 6 days later, for possession of meth, no driver's license. No, excuse me, not then. He was arrested September the 5th. He bonded out of jail on those 2 charges. He was arrested September the 5th, possession of meth, no driver's license, no insurance. He bonded out then. He appeared last time here on September 14th. That was in case 17-370. Possession of methamphetamine, no driver's license, no insurance. At that point, he was out of jail for about 12 days, and he picked up a new charge of possession of firearm by certain persons and a drug paraphernalia charge. This gentleman has got 5 cases in the last 6 months. He's actually been arrested on felony offenses 3 times in this last month, in about 25 days. The bond that we would suggest is a $25,000 bond with an ankle monitor and subject this man to house arrest. Your Honor, taking methamphetamine is one thing. He's driving an automobile, I guess at the same time as taking methamphetamine, and he's done that 3 times. That's a lottery that there's a lot of folks driving don't really want to win, as this man is driving around in a car and he has no ability to pay for any damages that he has. And I don't want him to hit somebody. He's not going to stop. I recognize that. I'd like an ankle monitor. I'd like him subject to house arrest, and I'd like a $25,000 bond.
Mr. Cooper.
Your Honor, if the $25,000 bond is going to cover all the cases, defense would not have a huge argument that I think that the court is going to listen to anyway. You would listen, I just don't think that the court would rule in my favor on anything less than that. The house arrest and ankle monitor are 2 conditions that would seem to be overly strict considering the amount of the bond. I would have no argument with the bond being at $25,000. I would have an argument with the ankle monitor. The ankle monitor, as I understand it, is an additional $300 a month at least. So in addition to posting what would be $2,500 plus a bondsman's fee, then he's going to be paying an extra $300 a month to be on an ankle monitor. And I don't really see why he would have to be on house arrest. So my 2 arguments would not be related to the amount of the bond, it would be on the ankle monitor and on the house arrest.
Your Honor, if he's on house arrest, he's not driving. And unfortunately, this man's going to drive. You have to drive in society today. You can't walk, you got to drive. The fact that you don't have insurance stops a lot of people, but it's not going to stop this gentleman.
Because I wasn't driving the last time.
What did you say, sir?
Yeah, I was not driving the last time.
He wasn't driving the last time, is what he said.
You know, I don't want to drive no more. I didn't.
Travis, that's enough.
Okay.
All right. Court's going to set the bond at the $25,000. It's a whole new bond. It'll cover all 5 cases. It'll be for $25,000, cash or professional bond. It will be conditioned upon the defendant will, from reading his affidavit, he's not employed. I don't know of any reason he'd have to ever exit his house, so I'm going to put him on house arrest. He'll be required to be at home, with the only exceptions to that, if he's out away from home, would be to attend a scheduled medical appointment or to meet with his lawyer. So those will be house arrest with those 2 exceptions. He'll be at home. If he's found away from home, he's subject to immediately arrest with a no bond hold. The court is also imposing a condition that he's not to have in his possession any form of drugs or alcohol or any paraphernalia related to drugs or alcohol. If he's found to have any of those items in his possession, he's subject to immediate arrest with a no bond hold. This will be the last time that this court's going to set a bond on this individual.
Thank you, Your Honor.
You may be excused, sir. (2017-376) State of Arkansas versus Corin Jamal Johnson. Court makes the appointment of the Public Defender's Office to represent Mr. Johnson. Mr. Johnson is for arraignment on charges of terrorist or threatening in the 1st degree. That's a Class D felony. On those charges, how does he now plead?
Not guilty, Your Honor.
Plea of not guilty is noted. Mr. Johnson is on the Division 4 docket of this court. court will be setting this for, at this time, it's going to set it for the court's scheduling order with a trial set the week of March 26th of 2018, a pretrial on February 22nd, and a reappearance on January 25th, all in 2018. What's Mr. Johnson's status as to bond?
I think it's set at $5,000 currently.
Your Honor, as I just informed the court, Mr. Johnson only applied this morning. I have not visited with him.
He's got a revocation out of Marion County.
I understand that there is a revocation out of Marion County. Bond may not be an issue here today if there's revocation pending in Marion County. Mr. Johnson, I'll get down to the jail and see you, and we'll discuss your case and your bond, okay?
Yes, sir.
Okay. Yeah, at this point, the court can't find, court is setting the bond at $5,000. That'll be, that's a cash surety bond. And
Trying to say something.
I understand. I'm just trying to read quickly the affidavit to see. I'm going to condition that bond on a no contact with whoever his alleged victims are. So that'll be the bond. What did you have to say, Mr. Johnson?
Well, Your Honor, I was hoping that I could get OR. I fully intend on fighting this case and doing the trial, but I need to get witnesses and evidence and visit with my public defender as much as he actually needs me to. So I actually can get back in the case, but I can't do it from here. I have to pick up today, and I
Sir,
still
you're gonna have to speak up.
I'm sorry. I said, I was hoping to be OR because I wanted to get witnesses and evidence in my favor because I'm pretty sure that I can win this case. Because I just need the freedom in order to go see my public defender whenever I need. If there's some evidence that comes to light or anything, so I was just hoping after the Marion County road, I could be OR.
Well, I'm at this point, I'm certainly not going to OR you. I'm not going to do that. I want you to meet with your attorney. Mr. Cooper indicated he'd be down to see you. And after he's met with you and we can see where things stand a little, then the court will consider other recommendations. At this time, based on what I've read in this affidavit, the court's going to set this matter or set the bond at $5,000. That's a cash or surety bond, and it will have a condition on it that you make no contact whatsoever with the people that obviously you were in some kind of altercation with and are alleged to have made threats against. So that's where this matter stands as of today.
Right.
After you met with Mr. Cooper, I will certainly be willing to entertain consideration of some kind of amendment to the bond. And if we can't agree, if I can't get enough information to set a bond to your satisfaction, my next appearance in court will be on October 19th, and we can take this matter up on October 19th. But that's where the matter stands as far as bond is as of today. All right?
All right.
You may be
Thank you.
excused. We have also for arraignment, we have 2017-378, State of Arkansas versus Kelly Hancock. Mr. Hancock, I have you down on a charge of failure to appear. Have you made any arrangements to be represented by an attorney?
Yeah, I'll have my family get a hold of Ben Burnett.
Mr. Burnett said you would not represent him.
It's my understanding. At this point, Mr. Burnett has indicated that he's not been hired to represent you at this point. So you either need to get in touch with your family and direct them to make a formal arrangement with Mr. Burnett, or
That's what I'll do.
all right. So, on the charge, which is failure to appear, it's a Class C felony. How do you now plead?
Not guilty.
I'm noting your plea of not guilty. This case is on the Division 4 docket. That's my docket. And I'm going to set you down with a written scheduling order. You'll be set for trial during the week of March 26th of 2018. You'll have a pretrial set of February 22nd and a reappearance on January 25th, all in 2018. At this point, I'm not going to set bond on you because I think you have already an order that commits you to the Department of Corrections. So
What's this one felon?
you may be excused at this point. 2017-216, State of Arkansas versus Doyle George. This is down for pretrial today because this case was set for trial during the week of January 8th of 2018. We have a November plea deadline date of November 16th. Is there a pretrial for today?
No, there is no pretrial. I would like to look at his bond before he's excused.
Okay. In June, the bond was reduced from $15,000 to $10,000 by this court, conditioned upon the defendant wearing an ankle monitor and no use or possession of drugs, alcohol, or any, and be subject to drug testing.
You know, he has been in jail, as the court's noted, since June. He can live with his mother, LaVon George, at 37 Campfire Lane in Mountain Home. Mr. George, to the best of my knowledge, is what he said yesterday at the jail, is a lifelong resident, or essentially a lifelong resident of this area. I would ask, Your Honor, that the court reduce his bond to $2,500. If the court's inclined to put him on house arrest, that's something that would seem reasonable. Again, the same argument I made previously about the ankle monitor. It's going to be very difficult for Mr. George to get out and afford to be on an ankle monitor. I think we're just setting up a recipe for disaster if we do that.
Your Honor, all of those arguments were made on June 22nd when this court entered a $10,000, but reduced this man's bond by $5,000, required him to have a ankle monitor and drug testing every Monday. There is nothing that has changed since that time. I would ask that the bond remained and the conditions of it remain exactly where you placed it back in June.
The court is satisfied he's a long-term local resident. The charge of delivery of methamphetamine and cocaine causes the court some concern. What was his status with regard to parole?
It's been lifted, as I understand, Your Honor.
It was reinstated, Your Honor. I would point out, Your Honor, I think on June the 22nd, it was pointed out, this gentleman has a criminal history of 3.0. He is no stranger to this court, neither this court or this court. A $10,000 bond with the concept that this man should be remain or be monitored is not, at this point, unreasonable. It wasn't unreasonable in June.
Your Honor, Mr. George, despite his criminal history, is still presumed innocent and is still entitled to a reasonable bond. I understand that the fact that he has not made bond is not a consideration that the court will entertain. In knowing Mr. George's criminal history, I'm not aware of him having anything in his past that is a violent offense. Now, maybe he's got something, I'm just not aware of it. He does have a criminal history. I'm not arguing with the number that Mr. Chisholm has given to the court, but he is entitled to a reduction of bond by the contingent of the defense.
Court's not going to reduce the bond at this point. The $10,000 already did it once. The matter is for a reappearance on November 16th and trial the week of January 8th of 2018.
Thank you, Your Honor.
All right, you may be excused. We have 2016-238, 2016-283, State of Arkansas versus Sean Eaton.
Your Honor, the defense had requested a separate evaluation paid for by the Public Defender Commission. That evaluation occurred at our jail this past Monday. We are awaiting the written results of that evaluation from Dr. Michael Wood. So there would be no action to take today, Your Honor.
All right. Because of that pending evaluation, the court's, I think, not permitted under the law to take any action on this matter. So I'm going to put him down, though, to reappear I'm going to put him down to reappear on October 19th. Because we should have something by then, shouldn't we?
We should, Judge.
That's the next time the court's here.
Your Honor, I think that we'll have something by the end of next week.
Okay.
Dr. Wood's been very prompt.
All right. So next appearance will be October 19th. You may be excused, sir. 2016-210, State of Arkansas versus Philip Wilcoxon. Again, this is a matter down for a pretrial today. Are there any issues for pretrial?
Yeah, there's not. I visited Mr. Wilcoxon this morning at the jail. He's actually in jail. It must be out of district court. I don't think it's anything from out of this court.
He was revoked in Judge Putnam's court for 89 days.
Oh, Judge Putnam revoked him. I wasn't aware of that.
So I'm noting there's no pretrial motions to be heard today. Is that correct?
There is not, Your Honor.
All right. Next appearance is November 16th. That date is a plea deadline on the charges against Mr. Wilcoxon. All right. You may be excused, sir.
Thank you, Your Honor.